Okay, I think we can start now. Good afternoon. My name is Spurgeon Kennedy. I am the chair of the NAPSA Standards Committee. If I can just move my forward. I'll be joined today by Barb Hankey, who's Director of Oakland County Public Services Department, Elizabeth Simoni, who's Director of Maine Pretrial Services, and Janice Dean, who is Deputy Court Administrator Administrative Office of the Pennsylvania Courts. Janice will be joining us in spirit, if not voice, and she'll be helping us man both the chat and the QA parts of this. Couple of housekeeping items. We want to keep chats and the questions about the webinar separate. So if you have a chat, just a general, hi or just a general message for folks, please use the chat function. If you have an actual question, please use the Q&A function at the bottom of your screen. Janice will be monitoring both of those, and we'll be able to make this work. As you may know, earlier this year, NAPSA updated its standards. We developed pretrial standards revised for 2024. In doing this, there were conversations within the standards committee and also with NAPSA's executive director, Wendy Ververla, that we should start to highlight some of the standards themselves, some of the specific standards to give people a better understanding of why NAPSA chose those standards, what the rationale was behind it. We just did actually a webinar or discussion with the Northwest region maybe a couple of weeks or so ago, where a few of the standards were topics, things that people believed were good standards, but not necessarily things that they might be able to accomplish as an agency. So this webinar really, hopefully, will be one in a series that really breaks down a specific standard, a specific core function that NAPSA believes pretrial agencies should be involved in, and lets you understand why why we created that function, why we think that function is important, how it relates to the central work of a pretrial services agency, how it complements other standards and other core functions that we believe agencies should go. But we also want to be mindful of some of the issues that are out there that might be holding some people back from doing core functions. And when we talk about the pretrial interview, we're talking about one of the most core functions for agencies. Pretrial agencies have been performing interviews ever since they were pretrial agencies back in the early 1960s. It is one of those original things that we did as agencies. It has fallen off some, I would think, in years for various reasons that we'll talk about. But NAPSA firmly believes that the interview is an important function for pretrial agencies to perform. It certainly provides information to the court that we think is essential, not only for a good, fair bail setting, but also for supervision. So we want to talk about the interview today. We want to sort of let you know where it falls into the core functions, into the principles of pretrial agencies. We want to talk about why NAPSA endorses the pretrial interview, our reasons for doing so. And we want to, as I said before, discuss some of the reasons we know that some agencies may not be performing interviews. So with that, let's start by outlining just what the purposes of a pretrial services agency are, to make sure that we're all on the same page about what agencies should accomplish, or at least should try to accomplish. The first one is assisting judicial officers in making prompt and fair, and most importantly, informed bail decisions that we hope will encourage persons to make scheduled court dates, promote public safety. In other words, you want to help judges and judicial officers make better decisions that hopefully will produce better pretrial outcomes. You also want to provide courts with practical and individualized monitoring and supervision. You want to make sure that if you believe that a supervision condition is needed, that is practical for the agency to perform it, or it's practical for the agency to find someone else who can perform it, and that it's individualized to the person in front of you. It isn't just a standard condition because someone fit a particular criteria or fit into a matrix box, but you're giving the court enough information to make those individualized supervision decisions when they need to be made. And finally, you want to measure. You want to track and report your outcomes, your performance. You want to see how well people are doing on pretrial supervision. And you also want to identify the potential problem areas that might be out there, things that the system might be doing that are hindering people from making court appearances or actually increasing the likelihood of a public safety threat. So tracking and measuring and reporting are really essential purposes of a pretrial services agency. With that, I'll turn it over to Barb Hankey, and Barb will talk a bit about the core functions of pretrial agencies.
Thanks, Kenny. And just sort of seeing in the chat and that some people are saying like black bars and on the screen over the slideshow.
Oh.
So Kenny, you can work on that maybe. While I talk, you have to excuse us. Wendy's not here to run this for us today, so we're sort of flying on our own. So there we go. Thank you, Kenny.
Sorry about that.
So as Kenny said, I'm going to talk a little bit about what actually is standard 4.1b, and those are the core functions that pretrial services agencies should be engaging in order to support those purposes that Kenny just talked about. So really, these are the things, the activities that make pretrial service agencies pretrial service agencies. So the first one is, collecting and verifying background information on individuals. Any individual that's eligible for pretrial release that's in your custody. So by collecting and verifying, basically we're referring to the interview. During the interview, you should be asking for references in order to verify the information. And then also looking at the criminal history. And the criminal history really needs to be include the national database, NCIC, III, multi-state, to ensure that you're getting a good picture. You may also need to be looking at other state and local databases. I think we all know that oftentimes there's missing information on a criminal history report. And in order to get the most accurate information to be able to score an outcome assessment, you need to make sure that you have true and accurate criminal history information. So you may need to call various jurisdictions in order to obtain that dispositional information if it's missing. The second thing is you need to be using a validated outcome assessment in order to assess the likelihood that someone is going to appear in court and or remain crime-free. Your outcome assessment should be based on factors that are shown by research to be predictive of pretrial success. And ideally, when you're validating your outcome assessment, you're using your local jurisdictional data, because that's really going to give you the best outcomes. The third one is that you're using all of the information that you've gathered from the interview, from the criminal history, the results of your outcome assessment, all together in order to formulate the best, most informed and appropriate conditions of pretrial release. And I'm going to talk about that a little bit more in the next slide. So we'll come back to that in a minute. The fourth one activity is that your pretrial agency should be offering some type of monitoring and or supervision for individuals who are released to ensure accordance with any court-imposed condition. And I think that this is a place where your staff really need to be cognizant about the services that are offered in your community. We've talked a lot about supportive services, and these things should be offered voluntarily in many cases. And so your staff need to be, again, cognizant of what's available in your community so that they can make those referrals to individuals that may be in need of behavioral health or other types of services in order to ensure that they appear in court and remain crime-free. This next one really goes hand in hand with the supervision and monitoring of individuals that are on pretrial release. We should be notifying the court and defense and the prosecution about how an individual is doing while they're on pretrial release. So I think too often agencies sort of rely on, oh, we're only going to be reporting when someone does something wrong or when there's a violation. But in fact, we really should be letting the key players know how an individual is doing when they're doing well, as well as when we're letting them know that they're having a violation. So this is really a chance to send activity reports or compliance reports, whatever you want to call them, to the court to let them know that the individual is doing well. I know this is a lot of work. In our agency, we send them for every court appearance, which again can be a lot of work, but it also gives the staff the ability to let the court know, hey, this person is doing well, and make a recommendation that maybe a condition should be modified and or removed. So for instance, if someone has been drug testing for 3 months and has had negative tests that whole time, the staff person, case manager might say, let the court know that the person's been in compliance, that they've had all negative tests, and that perhaps that condition should be reevaluated for removal. If we also are giving those reports to defense and prosecution, the defense counsel can also make those arguments because they'll have the information that they need going into those court appearances. And lastly, really, this goes to the idea of sequential bail review, that we should be reviewing the status of defendants who do not obtain pretrial release. Any individuals that remain detained really need to be continually looking at those individuals, informing the court that individuals haven't gained release. We often find that judges will say, oh, I had no idea that they were still in custody. They never meant for the person to stay in custody. So maybe they'll look at that condition, or if it's a financial condition, review that and do something else. There may be material circumstances that have changed. Perhaps charges have been dismissed or they've been reduced, and it's a good time for the court to reevaluate the bail that they have set. If you want more information about jail review and sequential review, go to NAPSA's YouTube channel. There was a webinar all about this just a few months ago that I believe Janice Radovick-Dean was one of the presenters in that. So Kenny, if you want to go to the next slide. So I wanted to come back to this idea of what constitutes the investigation. And NAPSA has recognized that there's really 4 components to an investigation: the interview, the verification, criminal history, and the outcome assessment. And all 4 of these components really work together as a checks and balance. And that's why we think the interview is so important. When we do training, a lot of times you'll hear from the judges, particularly from judges or those that are making the bail decisions, oh, you just believe whatever the individual is telling you. Well, this is the opportunity during an interview to get references, to check that information, to make sure any information that you're using in an outcome assessment has been verified and is accurate, and giving you the best information. So again, NAPSA has recognized those 4 components as being the minimum that should be in an investigation or a screening protocol. All right, Kenny, if you want to take it away, talk a little bit more specifically about the interview component of that.
So if we take one of those boxes out of the investigation, the interview itself, and look at why we think the interview is important and what purposes it serves. If you look at the commentary under Standard 4.3a, what it'll tell you is that the purpose of the pretrial interview really is threefold. One is, of course, to provide information needed for your agency's validated outcome assessment. many outcome assessments, for example, the VPRE, the ORAS, some of the more locally validated assessment tools still require demographic and qualitative data to be completed. You also want to gather information about other factors that might be relevant to the bail recommendation that you make and the court's bail decision. For example, is there a relationship between the individual charged with the crime and the alleged victim of that crime? Do they live together? Is this a domestic situation? Uh, is the person employed full time? That was my bugaboo. I never would want to have a person who was full-time employed with the verification of that employment, having an in-person reporting, condition to a pretrial agency. I just think it's counterproductive to what that person has going on. So there are things that you find out from the interview that can be helpful in making your recommendation and also helping the court form its own bail decision. You also, as I said, want to obtain that demographic and other information about the individual for effective supervision. Are there things about this person that make some supervision conditions impractical? Are there things going on in their life right now that might make it difficult to make court appearances or to remain arrest-free? The interview really is your chance to ask that very simple question. Is there anything going on right now that's going to keep you from making a court date or keep you from staying out of trouble pre-trial? You can ask the question, you can get the information, and hopefully you can help resolve or mitigate those factors that you identify. NIC, I had a really good quote about the interview itself and about its value in the pretrial system. And part of it had to do with providing context to what usually is very static, quantifiable information. For example, an arrest record, where you really don't get a good idea or the context behind that arrest, particularly arrests for missed court appearances, which might have a story behind them that you can ask during the interview. You also have the opportunity to really gather the essential information that you're going to need. Contact information. Are there people I can reach out to if I lose contact with you? How do I get in touch with you? What is the best method of contact? Is it mailing you something? Is it emailing you something? Is it sending you a text message? How do you want to be contacted? You can also help identify opportunities, if there are, for things such as diversion and problem-solving courts. In some states, interviews are actually required by statute, or as we said before, really needed as part of specific risk assessment tools. So there is great value, NAPSA believes, in conducting interviews. There's a lot that can be gotten from an interview. It's a lot of information that can be given to the court, a lot of information that a pretrial agency can consider and we think should consider in making its recommendation. So let's talk a bit more about the reasons why NAPSA endorses the pretrial interview. I'll turn this over to Elizabeth, who can start the conversation.
Thank you, Kenny. So this has all led to sort of a bullet point list as we'll move through the next slides. One of the reasons that NAPSA strongly endorses the pretrial interview is it is that opportunity, as has already been mentioned, to identify mitigating and aggravating circumstances that not only can help inform the pretrial practitioner or pretrial agency's recommendations, but also the court's ultimate bail decision. For example, one might see a lot of failures to appear listed in a criminal history. An interview might be an optimal time to ask a pretrial detainee, why is it that we see these 6 failures to appear during this time period between 2006 and 2008? And they might say, wow, I was hit by a car, I was hospitalized during that time period, I have records, or you can talk to my lawyer. Someone might have been in a residential facility. Sometimes we see people that have literally been serving a sentence and they were not ever brought to court from another jurisdiction. As Kenny said in a previous slide, it's the perfect time to ask the human being in front of you, is there anything going on that can help us today with your release, right? Is it a positive thing? Is it a negative thing? Sometimes we encounter someone that might be experiencing a life difficulty and requires some medical attention, or maybe there may even be a competency issue. And you can start to engage with the human being in front of you and see those factors. Next, it encourages that adjusted actuarial assessment model that the standards encourage. If we look at 4.1B3, I'll just read it to you. Use an individual's background interview and investigation, criminal history, risk assessment results, and other information to formulate appropriate risk assessment results. Recommend appropriate conditions for pretrial release and supervision, and supervise and monitor individuals released pretrial. The actuarial adjustment is when your risk tool says this, but reality says this. And we know with these tools, there should be a limited amount of overrides, but compelling information that's gathered during the course of an interview is a perfect jumping off point to say, do we need to adjust this or not? Third, it is required by a lot of outcome assessments, and we see that coming down through the chat. As was mentioned, the VPRE is a tool that asks for an interview. Some of that demographic information can only be obtained in speaking with the defendant. Same with a tool like ORAS. Fourth, it identifies pro-social activities such as employment that really shouldn't stand in the way of success and shouldn't be facing a barrier that supervision requires. So specifically what that means is if someone has a job, we should not set up in-person reporting that requires them to miss time from work or lose their job. If someone has childcare duties, we can find that out in an interview, and we can tailor what the conditions are going to be that are set by the court so that we don't jam someone up, to be colloquial. In the next slide, we'll continue our list and we'll look at more reasons that NAPSA endorses interview. It encourages supportive service model of supervision. That's been referenced a few times already in today's presentation. Again, it's a great time to talk to the human being and ask about what needs are there and make referrals to resources. It offers time and opportunity to complete brief screens that are designed to identify key areas for support. So for example, we listed the CAGE, we listed Columbia Suicide Risk Screening, the ACOK tool, which looks at mental health, substance use disorder, and trauma. These can give a quick overview into what needs might help mitigate risk of pretrial failure. Right? If we address someone's needs around SUD, for instance, they might have a better outcome. Doesn't mean it's going to be conditioned by the court, but it means if you are a pretrial agency that not only does interview and release, but also supervision, you can start to tailor what those interactions are going to be like. Number 7, it offers a well-trained interview, a jumping off point to engage in motivational interviewing. Motivational interviewing is capitalized for people that haven't annexed a lot of social service agencies or clinical agencies in their pretrial work. It is a specific technique where we can ask as an interviewer open-ended questions that are designed to help the person that we're talking to get to their own space where they think this might be a good idea or this might be a window for change. I have often been told by my family that I have this difficulty, and this person interviewing me, for some reason, I'm starting to think this might be a time to engage in services. That's that jumping off point that may help assist somebody in figuring out what resources are necessary. Again, we want to honor least restrictive release. So this doesn't mean that needs will become conditions. right? You can still be least restrictive, but still engaging with that human being so that they can move from a pre-contemplative stage to an action stage and actually engage in social services that help. Thank you.
Bob, you might be on mute.
Thank you, Kenny. I had forgotten I did that. So if those weren't enough reasons for you, there's more. So during the pretrial interview, this gives the staff person, the interviewer, a chance to talk to the individual about what rights they have pretrial, that they have a right to bail, that they have the presumption of innocence during this pretrial release phase. Now, you need to be careful that you don't cross that line and you're not offering any kind of legal advice, but it might be a time to explain some of the options, what OR means, what unsecured bail means, the different types of bail that they could receive so that the individual is a little bit knowledgeable about that when they go in for their initial appearance. We take it for granted because we know we do it every day, that we think everybody knows what OR means, but oftentimes the individuals are so overwhelmed, they may not understand what's going on. So this is a chance for you to talk to the individual a little bit about what might be happening to them, what they can expect when they get into court, and what the different options that are available to them. It also offers the agency or for your pretrial person to talk about informed consent and releases of information. Getting those things signed early at this stage very much enhances the flow of information. So the earlier you can get that information, and if you can include it in your bail recommendation, inform the court if someone's already in some kind of behavioral health service or in mental health services, and you can obtain that information and include it in the report and as a recommendation potentially for the person to continue in that service. That really, I think, helps and gives a lot of peace of mind to your judicial officers. I know that sometimes this can be difficult. Obviously, if you're doing interviews virtually, you may have to come up with a way for an individual to sign. Sometimes if you're doing even in-person interviews, it's difficult to have an individual sign because you can't give them a pen, to sign or pass information back and forth. But really, this is the opportune time to get any kind of release of information signed. So if you can make it work, this is really the time to do it. And then, as has been mentioned already several times, this is really the opportunity to identify those barriers. As Elizabeth said, I see that you've had multiple fail to appears. What can we do to help you get to court in the future? Or what were the reasons behind those fail to appears? And again, then include that in a recommendation and acknowledge it to the court that while the individual may have had previous fail to appears, we can provide service to ensure that they get to court, either through bus passes and or subway tokens or cards or Uber or Lyft rides. There's also, I think that just gives a level of comfort to the judicial officers, knowing that you have addressed those barriers and you're already putting things in place that will combat those barriers. I think it's also important here, particularly in cases of domestic violence or other assault cases, you can ask the person, if the judge releases you and if they institute a no contact order, do you have an alternate address? Get that up front, again, so that you can advise the court that should the person be released, they have an alternate address that's been verified that they can go to so that they can make sure that that no contact order is adhered to.
And I'll jump back in. Even more reasons, if you're not convinced already that the interview is a great idea, we're going to continue. In jurisdictions that use sequential bail review, we used to call this jail sweeping. It's knowing exactly who's in your jail. And if they don't make pretrial release after the first initial appearance, Do you go back and sweep? Do you talk to them again? Do you find out why it is that they couldn't get out? In jurisdictions that engage in that, and that is a NAPSA best practice standard, it provides a record of pertinent information that can inform the pretrial practitioner of any material changes of circumstance. And I use the quote because that's something that we often hear in the system, and that's a lever. If there's been a material change in circumstance that's different from what was presented at the initial appearance, that provides attorneys and jurists another time to look at bail and say, let's examine what changed. So it might be, I lived on Elm Street the first time and they said, nope, it's too close to the alleged victim's house. We can't do that. Well, I went back in on my sequential bail review and I see that there's an address change. I sit down, I talk about it. I find out we are now very far from where the alleged victim is, and it seems like it's a safer bet. We're going to take that back to court. Another example is it provides an opportunity to express your humanity when you're working with someone in lockup and offer the appropriate linkages for assistance. This gets into a really, I think, philosophical and heady notion called procedural fairness or procedural justice. And it's really interesting. It's not just, it sounds good, so it is good. There are studies after studies that talk about when a decision is made, if it is transparent, if there has been the right to be heard, if someone gives notice, like Barb was talking about informed consent before, like I want to talk to these people, and they come up with a reasoned decision, then no matter what the decision is, the person at the other end of the decision about whom the decision is made tends to feel like they received justice. They were treated fairly. This goes a very long way in our very difficult criminal legal system. So it's really important to engage in that way and express that humanity. Also, it creates an avenue for individuals to request help from pretrial agencies. I think about one of our offices, it's a larger jurisdiction in Maine, and our staff have created what they call a resource hub. If people have to come and check in person, we don't have to push linkages on them. They can view things in a waiting room with privacy. They can take a pamphlet, they can take a business card, they can take a phone number. They can also ask, like, have you ever used this service? We often encounter people who are waiting to be seen as a check-in or reporting, talking to other people. What was your experience with this agency? Oh, I think I'll give it a try. We also have peer resources. So it's a chance to create that trust, and it feels like a personal touch, but it's a highly professional touch. Here's a resource. So thank you.
So, as you heard, there's at least a baker's dozen of good reasons NAPSA believes for the pretrial interview. And these reasons come from the experiences of pretrial agencies and people who've been in the pretrial field almost since the beginning, almost 60 years ago. That said, we understand that, as you mentioned before, this is no longer a universal thing that all pretrial agencies do. Some agencies have frankly given up on pretrial interviewing, and they've done it for a variety of reasons. I want to identify some of those reasons, and I'll ask Barb and Elizabeth to help me out with this. I don't want to be hectoring everybody all by myself, but we want to look at some of those reasons. We'll ask you in the chat if you want to give other reasons as well, and sort of talk about them and why we think that while they might certainly be barriers or they might be things to consider, they shouldn't be considered barriers to performing an interview. So what are some of these? Ex Excuses, I love that word, for not conducting the pretrial interview. Well, first off, my outcome assessment doesn't require one. You know, I use the public safety assessment or some other tool. It doesn't require an interview. Why should I do an interview? It's really that simple. I was told that if I adopted this assessment tool, one of the benefits of adopting the tool was it doesn't need an interview. But I think as we had said throughout this presentation, You're doing more than just presenting the results of an outcome assessment to the court. If you really want to have an informed bail decision come out of everything, the court needs more than to just know that a person is a low moderate or that they hit a particular box and this is where the matrix is they need to go. That additional information can only come from one source or a couple of sources. And the interview, we believe, really is one of the most important. So again, if you want to provide the court with a fuller picture of who this individual is, and I think you have to do that if you're in the business of making individualized bail recommendations and individualized bail decisions, I think you need something more than the results of an outcome assessment tool to do that. Now, Elizabeth, Barb, I don't know if you have anything else to add to that.
I guess I would just say, we know from looking at, studies that regardless of whatever outcome, assessment tool that you're using, there is a percentage of error, right? Like it may accurately predict 80% or 85%, but we could do better. If we use the actuarial, approach, as Elizabeth suggested, using the things that we gain from the interview to make those predictions better when there's an aggravating or mitigating circumstance. So just because it doesn't require it, we know that there's a margin of error. Maybe we can even lessen that margin of error and improve the likelihood of court appearance and or remaining arrest-free by using that additional information.
I would simply add, if you're in a jurisdiction where you might be the person that does the interview and you also might be assigned to the case for release, supervision, and monitoring, you have a chance to make a connection with a person, and you will probably statistically increase the likelihood that they engage with you because they met you at a time that was really difficult for them.
And I'm sorry, just one more thing, because I had forgotten to mention this earlier, but just because your outcome assessment doesn't require it, you need to look at your court rule, because oftentimes there is additional information that a judicial officer must take into consideration under the court rule that is not available in an assessment, or not under, required under the assessment. And so by doing the interview, providing that information to the court officer, you're really making sure that you're in compliance with the court rule, so that they can take all of the information they are required to into consideration.
Right, thank you. Reason number 2, logistical issues, getting to people before the bail hearing. Yeah, the jail can be a very large and complex place. You're not the only one trying to get to people. You might have a public defender who's trying to interview their client before court starts. The jail itself might be conducting assessments, assuming that the person might be there after the court hearing. So it might be difficult for pretrial to find its way, into that mix before the actual bail hearing. I would note, though, that this is something that agencies do every day, that everyday agencies like yours and its complex jail systems as yours, who have the limited time between that arrest and the time that a person is going to see that first judicial officer for that initial bail hearing, they have developed ways of dealing with that. Yeah, it is difficult, and yeah, it's going to be time consuming, and sometimes you may have to stretch it to another hearing to make it work in some places. But simply going, there's stuff in the way, really shouldn't be a good reason not to try to attempt this.
Yeah, and
I
that
would
may mean,
offer, go ahead.
I'm sorry, Elizabeth. That may mean, like in Janice's organization, they are working 24/7. So maybe you don't get to work 9 to 5. Maybe you have individuals that are coming, either working throughout the night or coming in at, 5:30, 6:30 in the morning in order to get to those individuals prior to their bail hearing.
Yeah, if it's important to you, I think it's very, very much appropriate to try to make it happen. We used to be asked to work from 8 to 4:30. We asked special permission. Can we enter the jail at 7? Absolutely. Come on in. It's a better time for us. The other thing is, we've all lived through the pandemic. If we could get to people and interview them then, when jails were locked down, we can do it really anytime. I'm an optimist that way.
Sure. Takes too long. This was one of my favorites whenever I hear it because my answer is it shouldn't take long at all. The typical interview is a 10 to 15-minute affair, I think. Maybe a little longer, depending if you have a person with a more creative criminal history than most. But if you find yourself asking a lot of questions, if you find your interview taking a tediously long amount of time, I don't think the answer is, well, we need to stop interviewing. You need to look at the interview itself and ask yourself, am I asking too many questions here? Every question needs to be associated with your outcome assessment, associated with supervision, associated with getting to those factors that should be considered as well. If you're busy asking me how tall I am, what my eye color is, uh, you know, things like that, and I've seen pretrial interviews that do that, then yeah, you're wasting a lot of time. And I would say that if your interview takes a long time, that's a red flag for you to really check the interview itself, not to stop doing it altogether.
There's a really fun session in the fundamental tracks at the NAPSA conference. And if you have not attended interviewing 101 at NAPSA, I highly recommend it if you are lucky enough to be going to Atlanta this year. It really gets down to the nub of that and how to quickly redirect while being efficient and effective and polite, but staying on track and getting that done. And as Kenny said, tying it all back to what is the risk that has to be addressed.
Agreed.
Verification of interview information is hard to accomplish before bail setting. Again, like logistic issues, you're absolutely right. It sometimes can be very difficult to get verification of where a person lives, whether or not they're working, where they say they're working, all kinds of things. But again, it is something that is important enough to be attempted. And if you're not able to verify information, be very honest with the court about it. Just let them know that this information was given to you by the defendant, but not verified. And if, as a condition of supervision, that person should provide information or verification of information after release, that certainly is an option. That's something that the DC pretrial agency has been doing for a number of years, and it is a condition of supervision or monitoring that we've convinced our courts has some value to it. So, again, just saying that it's in the way doesn't make it big enough not to do. And there are ways that you can make this work, either before the bail setting or afterwards.
And Kenny, I think for those of us who have been in the business for a long time, this has changed over the years and why it's difficult. It used to be because, prior to the cell phone age, you were trying to call people on a landline and maybe they were, already at work or this and that, and it was difficult to reach people. Now in the age of cell phones, everyone has their cell phone with them. It's easier to reach people. But the reason now it's harder is because nobody knows anybody's phone number. And so that's, I think, what makes it, more difficult. And that's really the challenge. And so I know that there have been agencies that have worked with their intake, deputies or officers to have people write down a few phone numbers prior to their phone going into their evidence locker or into their property locker so that they have, those numbers available, to give the pretrial investigator so that we can contact someone.
Yeah, it's a great point.
Finally, I would just add, think about what it is that you are independently verifying and why. If you're pressed for time, if there's a couple of items that you would normally look for independent verification, tie it to the risk. Say you have a domestic violence allegation and you want to make sure the person is not living with the alleged victim. Triage and put your priority around where is the residence going to be. and maybe not so much the job or the volunteer or whatever, right? Like really focus on how do I mitigate the risk?
Yeah. Number 5, lack of staff. Sometimes you might be in a jurisdiction where you are a one-person pretrial agency, or you may have a couple other people working with you. And you may believe that because of that lack of staffing, you're not going to be able to do everything that the standards say that you need to do. That was a point that was certainly brought out when we met with the Northwest region a few weeks back. Some of us are just small agencies, but again, even a small agency, we believe, needs to be able to handle what we think are the core functions. And again, even with the lack of staff, you need to figure out a way of getting that information to the court. Again, it should not be that because you are lacking in people, you're going to take back something that the court really needs to make good decisions. At the end of the day, no matter how many people you hire, your pretrial agency is there to do those core principles. And you can't do one of those without an effective interview. This is one that I really, really sympathize on because I hear you when you say it. I don't want to identify a potential need or service when there's no way to to provide a service for that need. So I don't want to say to a judge that the person has behavioral health issues if I know that my jurisdiction doesn't have behavioral health options. That's just putting a big red flag on them to say, put this guy in jail. Do we really want to be in that situation? And I understand the back and forth on this. I really do. This is one of the tougher ones. Do you want to be in a position where that information is the sole reason or one of the reasons why a person who may be getting out is now being detained? However, my take on it, as hard as it might seem, is that, yeah, this is information the court needs to know. This is information that your system needs to know, not only about an individual, but about the people that go through their court system. Are we consistently seeing this kind of need pop up? Are we consistently seeing this kind of risk pop up in our population? And if we are, what are we going to do about it? Again, sometimes the beginning of creating those services is identifying the fact that you need those services. So again, I would strongly urge you, even with that in the back of your heads, to continue to get that information and report it.
Yeah, Kenny, I agree with that. I mean, so often, we talk about how there's a lack of data, and I think that this is one of those areas. So because trying to quantify what the actual need is can be difficult, and maybe people who control the purse strings are only seeing a handful of people, and you're seeing it every day. 80% of the people in front of you might need a particular behavioral health
Mhm.
need. Even just documenting that so that you can show percentages of individuals that need that particular type of service, I think helps start setting the stage, as Kenny said, quantifying what is the need, trying to find a way to fund that need and get it off of the ground. But it is hard. But for those people, when you don't have it, asking about it, but it's really the only way that you can begin to get a handle on how large is the need and what is the breadth of service that we need.
Yeah.
And remember, if you have the data, you become an exceptional grant applicant. If there is an opportunity, either locally or nationally with funding, you'll know what's needed and you can state your case quite well.
Yeah.
And
Is
Kenny,
it?
I'm sorry,
Yeah.
I just want to go back for a minute because I saw someone to number 5 about the lack of staff. Because
Uh-huh.
someone, popped up in the chat and they're like, well, I had hoped you had, a solution for the one person show. And I would say that what we're talking about here in documenting is also important when you're talking about lack of staff. How many, potentially people were you unable to get to? You provide the service, the full service for as many as you can, but because it's only one person, we may have not been able to get to these others. Or how do you prioritize? There are some jurisdictions who may be like, we release all of these types of charges anyways. We don't really need a report on those. So focus on, these types of people. So I think that that's something that you can do, but it's not an excuse not to do everything, but prioritizing for the sake of being able to show that you need more staff because some individuals are not benefiting from the full service that you offer.
Yeah. And lastly, another one that we hear quite a bit, and it's unfortunate. My court doesn't want the information. Hey, they barely want the risk assessment result. Now you're telling me to write a report that they're going to ignore as well. I think that this is something, and I've heard judges say this. Judges sometimes don't know what they need until you show them what they need. We were in training, Janice and me, in Pennsylvania, with a group of bail setting judicial officers there, and someone brought that point home that they didn't like this thing called pretrial. They didn't like this thing called, risk assessment and all this information. I know how to make a decision. I'm a judge, for God's sakes. I wear a black robe for a living. It wasn't until they actually started getting the information and they started to see what the information was, and they started to understand how that information could be used to help them make better decisions, that they became one of the biggest consumers for the agency, and they became one of the bigger advocates for the consumers. So I would really suggest that even if the court doesn't want to keep giving it to the court, and meet with your judges and let them know what's in that interview, what's in your report, and how you come about it, and how it's verified. And the more they learn, hopefully, like the judges we met a couple of weeks back, the more they learn, the more they'll grow to appreciate it. So again, understand it's a problem, certainly, but it shouldn't be a barrier to prevent you from doing something.
The other thing is, if you're responsible for supervision and monitoring, you want that information as well. So what Kenny said, and then also think about your own job duties, and you will have a better picture to be able to help uphold whatever the court conditions are, but also to meet some of those unmet needs and lead to success.
All right, enough yelling at you. We're going to end this with one more slide, and Elizabeth and Barb will take the lead on it. We'll all sort of jump in as needed. And that is what the rules should be in conducting pretrial interviews. What should you be mindful of? What should you be made assured that this is part of the policy that you put together? So I'll let those two take it away.
Yeah,
So
thanks, Kenny. So
go ahead.
these are things, as Kenny said, like NAPSA absolutely, encourages an interview, but we do have to be careful, and there are some rules around the interview. I'll take the first one, just that when you sit down for an interview, you need to inform the person why you're there, introduce yourself, let them know that the interview is voluntary, and that they have the absolute right, informed consent, to decline the interview or not to answer, specific questions. You never know, they may have already talked to an attorney or have an attorney of their own that has advised them of certain things. So that shouldn't be held against them, the fact that they maybe don't want to answer certain questions and or decline the interview altogether.
And if you're looking for that in the standards, we call it admonishing the defendant. When you show up in the room to interview, let them know who you are, where you work, and what the scope of the questions are going to be, and that it is voluntary. The second one is similar. Don't ask about the current charge or the circumstances of the arrest. You don't need to know that as a pretrial practitioner. You're there for a different purpose. Your interview should never look at guilt or innocence. We are not the finder of fact. That's a judge, that's a jury, right? So not our lane. So don't go there, period. There was a pretrial expert Tim Murray. He used to talk about walking from his office in Miami-Dade, from the jail to the office, to the courthouse, and having police reports in his hand and thinking, if I look at these, I'm going to burst into flames. Well, he wasn't really going to catch on fire, but he didn't want to know about guilt or innocence because he understood his role was about looking at risk for the primary elements. Are you going to appear for court? And are you going to be rearrested?
Yeah. This is a little harder sometimes than you think because, and think about this, you've been arrested. Everyone that you've been in contact with so far has either wanted to put handcuffs on you or wanted to put you in a cage somewhere. And all of a sudden comes this bright, shiny pretrial services officer saying good morning, calling you by your name, being the first friendly face you've seen, since this whole thing started. Naturally, you're going to want to talk to them. And naturally, for certain people, you might want to start talking about things that you shouldn't talk about. This was a mistake. It wasn't me, all that. And it's really important that if you find yourself in that situation as an officer, as Elizabeth said, you put a stop to it immediately. You let them know, I'm not your attorney. I'm not here to talk about the case. In fact, in some jurisdictions, if you tell me something, I'm now obliged to give that information to the court. So let me do the talking. I ask questions, you answer them. That's where we are.
Okay. It's great advice, Kenny.
Hmm.
And again, attend that Fundamentals Interviewing 101 at NAPSA because they talk about, as Elizabeth said, redirecting and ways that you can shut that down. The third one we have here is that really you should be sharing that information with the court, with the prosecution, and the defense. Your recommendation shouldn't be a secret, and the information that you have should be shared. In fact, in our jurisdiction, we give our interview pages to defense counsel because, as Kenny and as Elizabeth said, sometimes everyone trying to get in and interview the individuals is a logistic nightmare. Many times the defense counsel does not have a lot of time to talk with their client. And so why should they waste that time talking about the same things or asking the same questions that have already been asked? This way we can give them the information and then they can focus on advising the individual what their choices are, what's going to happen, and how they move forward with the case. So it really does help the entire process when you share that information.
And with that, I'm going to take us, we'll the other bullet points, but I'm going to take us to the last bullet point because it's a natural connecting. Secure the individual's written consent before sharing interview information with other stakeholders. This is really important. So if you're going to share any of the information, you have to have informed consent, and it should be signed, it should be dated, it should have a period of duration in order to stand up to what would really be scrutinized as, was this informed consent or not? For us in our jurisdictions, we look at who's going to be in the courtroom so that if we have to make a recitation around the recommendation or answer any questions posed by a jurist or a party, we want to make sure we're covered. So we even have sheriff's transport listed on our informed consent because they're going to be in the room if they physically brought them to the courthouse, and they're going to be in the room if they're running video arraignments, right? So it's who is there, who has the right to know, and that's why we put that in there. So, and then hopping back up, using the interview information to develop a bail recommendation to the court. So take what you've learned and think about what it is that's needed. What can come from this? Connect those dots. This is not just good information. We're not just nosy people. This is going to help the court make a rational release decision. And I've been at this work more than 3 decades now. The most common thing I hear from judges is the 2 hardest points in the system for decision making is the release decision and the sentencing decision. This is a big decision, so any information you have is helpful for that recommendation.
And the last one here is not precluding an individual from a recommendation simply because they've declined the interview. So while NAPSA supports an interview, again, we recognize that the individual has the right to refuse that interview, and we shouldn't punish them for exercising that right. And so still make a recommendation. You still have a multitude of information sources to draw from in order to make that recommendation. Or you shouldn't, indicate that they're not a good release candidate simply because they, decline to be interviewed. Make the recommendation the best that you can on the information that you have available to you.
Yeah, absolutely. The last thing you want to do is make a truly voluntary exercise coercive by saying, look, okay, you have the right to refuse, but if you don't talk to me, I'm not going to make a bail recommendation. And if I don't make a recommendation, the court's not going to release you. Again, every defendant has the perfect right not to talk to you. And don't turn that right into something it shouldn't be. All right. We have one more slide, but I'm going to hold that off until the very end. It's a link to a survey that you can take to let us know what you think about this particular webinar. But for now, let's go into questions and answers. And I'm going to stop sharing because I can't see either the chat or Q&A when I share for some reason. So I believe we have one. Okay. Would you be able to share an example of a consent form? You have an anonymous attendee. Yeah, we probably could. I don't have one on. I don't know if you guys have one that we can drop into the chat box, or we can drop into the.
And it looks like Elizabeth is looking hers
Oh,
up, and we'll share it, and Janice is also typing something. But I would also just caution people while they're looking for those examples, and I know they both know this as well, is make sure it's written in plain language. Informed consent can, maybe get a little legalese in some cases. So make sure that if you're giving this to the individual to look at, to read, and to sign, that it's written at a level where the majority of individuals in custody will be able to read and easily understand and digest what it is that they're signing.
thank you.
Just one little point of advice. It's taking me a minute because I'm looking at multiple screens, but I'm going to share a form. We're careful in our jurisdiction when we are going to do informed consent for anything, whether it's pretrial release or treatment court work, which we also do. We have the Attorney General's office of our state review for the legalese. And then we make sure to also explain verbally because it does get a little heady in there. So I'll send something in 1 second.
Don't see any other questions. I guess we can.
It looks like there were some
That were
that were
answered.
answered that, Janice jumped in and answered for us. So thank you, Janice. But we might want to share, Kenny, maybe share those for, I don't know if everyone is looking at the chat, and so some of the questions might be helpful for the larger audience.
You made the questions in the chat?
No, the questions that Janice answered for us in the Q&A.
Sure. Okay. I'll call those up.
And one of them has to do with a major concern. It says major concern for our judges is ensuring that pretrial officers are not put in a position of discovering incriminating information, and how do we, protect the rights of individuals conducting a useful and thorough interview. And Janice had indicated, that staff need to be cognizant and tell individuals prior to the interview, which goes to what Elizabeth is talking about with informed consent, how the information is going to be used, and that they shouldn't be talking about the elements of the alleged charge or anything that happened. So there's also other places where this could be problematic. So for instance, in asking individuals about their substance use history, if an individual answers that maybe they used yesterday, if you have an overzealous, prosecutor, they may try to use that against someone. So having these immunity to subpoena agreements that you might be able to get with your prosecutor about some of the questions or information that's given in an interview might serve to alleviate some of those concerns.
So Janice is typing an answer to this one, but Dean Crump has asked, are there particular areas where interviews should be done? Kind of a follow-up to that, meaning we have to do some in booking areas, some even in the housing pods. Do you have any particular safety concerns to address? Yeah, I think that's always a primary concern when you're talking about where interviews should happen. I I as we used a slide in the beginning that showed an interviewer and defendant in the same room. I would never want that situation. For example, I would think there's always some barrier that needs to be between you and the person you're interviewing. So I would think that any place that just isn't an open space is the place that you can conduct an interview. And Janice would like to answer that live? No? Okay.
And I'm sorry, but yeah, I just the Q&A that you talked about just came up on my screen, so I'm sorry. That's I was like, what's going on? Okay, yes.
Yeah. Another one that I think is worth talking about, a major concern, this is from John Sabatini, a major concern for our judges is ensuring that pretrial officers are not put in the position of discovering incriminating information. How can we protect the rights of clients while still conducting a useful, thorough interview? I would underline the word thorough. Maybe one of the problems is what you're asking right now. Yeah, that is a legitimate concern. As we mentioned before, I think Elizabeth made the point. Nothing in your interview should point to asking about the charge, asking about the circumstances of the arrest, asking about the circumstances or the nature of the charge. If those are the kinds of questions you find yourself asking, then those are the kinds of questions that you really need to get out of your interview. Janice again mentioned that one of the first things you should tell your interviewing staff, they shouldn't talk about the crime. They shouldn't talk about circumstances. They should be told at the very beginning what the interview is for, how it's going to be used, and what you don't have to talk about as the person being interviewed.
Mhm.
I've gone ahead and emailed the release of information form to my colleagues here. I'm not the most adept at screen share in this situation, so just want to be open about that, but it is on its way. Thank you.
So there's been one additional question in the Q&A in the open. And it asks, what's NAPSA's position on conducting interviews virtually as opposed to in person, or having a stakeholder group such as the sheriffs conducting the interview on our behalf? So go ahead.
I'm happy to dive in. I obviously don't represent all of NAPSA, but I can say we all conferred as colleagues during the pandemic, and we embraced utilization of virtual technology in order to access defendant. One of the things that was really important to us was making sure that if we were interviewing someone using a tablet or Renovo or a telephone, that they were actually in a space in detention where they could speak to us and answer the questions without fear of other people listening. For us in our jurisdiction, that's really important because we do complement the interview, which is brief, with the tandem tools for need and risk. And so those sometimes require talking about things that are sensitive in nature. So for me personally, as a practitioner, we endorse the use of virtual if it is necessary. If we can get into lockup, it's so much easier because if we have forms, for instance, the release of information, then we're going to be able to execute that, to go over conditions, look at things and be really transparent. I will also say, not speaking for NAPSA, and I'll be interested what my colleagues say, I would absolutely not recommend a sheriff's partner or a stakeholder conducting the interview. I have the luxury of working for a private nonprofit. Our organization is identified as independent in the system. If you want to nerd out with us, and we invite you to do so, please look at the NAPSA standards and look at section 4, which talks about the pretrial agency. An arm of government, the executive branch, can do pretrial. The judicial branch can do pretrial. But you have to have your own locus of control. You have to have your own mission. And so in doing so, you also have to be adequately resourced, and you want to be able to have your pretrial practitioner who's steeped in your mission, who understands the purpose and the rules and the standards, do that interview. Having someone from the executive branch who is clearly in the role of executive branch or law enforcement probably, to me, would not be the way to go at all. I had one instance when I was a young practitioner where I had a conflict of interest with someone that I needed to interview, and it had to happen right then and there. Limited time, big case, heading to court, and I have a conflict. I worked it out with all the parties so that the defense attorney would do the interview, and it was what it was. But that was as close as I could get. Like, you're defending, and so you can have this sensitive information. So those are my thoughts on that.
Yeah, Elizabeth, I would agree. I don't think anyone in NAPSA would really support, particularly having a sheriff do the interview. As you indicated, in the standards, it says that pretrial is a neutral, independent agency, and having a sheriff's deputy conduct an interview is not neutral and or independent. And you're trying to build trust with this individual. And right from the get-go, there's going to be a barrier. An individual may not be willing to share the information with someone from law enforcement that they might be willing to share with someone that they're seeing, as Kenny said earlier, who's been a person that's been friendly to them, called them by their given name, treated them with respect and dignity. So yeah, I'm not in support of that either. And we'll turn it over to Kenny I know it's chomping at the bit to answer this one.
No, I think you guys are right. It's really hard to have on a uniform and a badge and convince someone that you're impartial about what's going on right now. Certainly, there's a role that law enforcement is playing. It certainly is playing in the heads of the people that would be interviewed. This also comes into play when we talk about other agencies that get the same information that pretrial services agencies do. And whether, hey, instead of me sitting down and asking this guy the same questions that the intake person just asked them, why don't I just get the information from intake? Well, I don't know how intake gets that information. In some jurisdictions, if you have a license on you, your address on your license, fine. This is your address. I'm not even going to bother to ask. It's not verified. You probably are trying to give that intake officer a different perception of you. than you probably would want to give a pretrial officer. I'm really not, and again, this is not NAPSA's position, it's just mine. Really don't think that pretrial agencies should rely on information gotten from other agencies in the process. But yeah, definitely sheriffs should not be conducting pretrial interviews.
And then just to back up, Dean had a follow-up question in the Q&A and talking about, safety concerns. And, that's always something, being in the line of work that we're in, that you have to be cognizant about. But I can say, been in the business 38 years, never had any staff or myself ever assaulted. And we would do interviews in wide open areas, in the uncuff, in back in the booking area, sitting on a bench next to, the individual doing the interviews in the old days. And so, but that's not to say that you need to make sure that your people understand if for any reason they feel uncomfortable, something jumps off, personal safety, and we teach this to our staff, personal safety always comes first. If you feel the need to just get up and abandon that interview because you hear something going on, then that's what you need to do. Personal safety always comes first.
Definitely. I think we may have lost Janice.
Janice and I both lost connection at the same time, and I think she's
Oh.
on her way back in.
Okay.
Thank you.
Sorry. All right. So I'm going to share my screen again, if I'm able to. And hopefully that's being shared. Hopefully what you're seeing now is a link to a survey that you can take. Just follow that. It's actually just a small questionnaire, getting your opinions about this webinar, whether or not you'd like to see others like it, whether or not you thought the topic was worth your time and effort in the hour and a half that we put into it. Again, one of the things that NAPS is interested in is what standard or what standards you want to get more in depth about, that you want to learn more about, that you want more of the history and background that perhaps the commentary gave, the rationale for having them, and whether or not the next time we get together as a standards committee, which will be very soon, perhaps we need to rethink that particular standard or where we're coming from with the standard, or just be clearer about some of the aspects of that particular function. This was the first one, the first webinar that really delved into that. We hope it won't be the last one. And we certainly appreciate everyone who took the time to be with us today and to talk about the interview and to let us tell you why we still think it still has value in what we do as pretrial practitioners. And with that, I will, unless there are any other questions, I will say thank everyone for the time that you spent with us, and we will talk to you in the future. Take care.
Thank you.